We are ready to go live. Hi, everyone. My name is Chris Richardson, President and General Counsel of BDV Solutions. And today we have Dr. George Pappas, who's an attorney and former federal immigration judge today. And we're going to talk a little bit about the EB-3 visa and the process for green cards in general. But I think what a lot of people want to know about is, given the environment that we're in today, how should people respond or think about if they have an encounter with ICE? Like, what are their rights? What are things that they can and can't do, and what they can and can't say? And we thought that who better to hear that from than a former immigration judge. Welcome so much today. It's really nice to have you.
Thank you, Chris, and thank you for BBD for inviting me. And I look forward to answering your questions. And hopefully people will come out with more information and feel more confident.
Perfect. Now, tell us a little bit about your background. Tell us about who you are and where you're from and how you got to be an immigration judge.
Well, I'm a product of an immigrant family. I'm Greek. My family came here after World War II. I grew up in New York City. I was born in the United States, but I'm also a Greek citizen by birth. Unlike the United States, if you're born to Greek parents, you're a Greek citizen. So I grew up in New York City, and fast forward, I've been practicing immigration law for 23 years, and 2 of those years were also as a federal immigration judge in Boston and Chelmsford, where I handled mostly asylum cases and cancellation of removal and a few other issues. So I've been involved in the immigration arena now for a good 23 years. I'm based out of Asheville, but I have offices in New England and Boston, so I'm commuting between both offices. But as you know, immigration is not only national, it's international. So clients that I serve are both here, across the country, and across the world. And whether it's business immigration or removal or, green cards or citizenship at USCIS, I've been involved in all of these areas for 23 years, Chris. So in a nutshell, that's where I'm coming from.
That's perfect. Thank you, Doctor. Now, tell us a little bit about, so did you, in your experience as both an immigration attorney and as a judge, have you encountered and seen green card holders, particularly EB-3 unskilled? And tell us a little bit about, what is the process for getting that green card through an employment perspective instead of a family-based perspective?
Well, from the EB-3 standpoint, the employer-based category, certainly the U.S. employer has to demonstrate to the Department of Labor that they cannot find an employee, a U.S. citizen employee. Obviously, a foreign applicant has to have certain skills that match what the employer is looking for. That's a starting point, but the employer has to not only accept the wage determination from their state Department of Labor, because those wages are set not by the employer, but by the Department of Labor. And the employer has to show that any wages offered to the foreign applicant are at least what would be paid to a U.S. worker. And that takes time. I mean, assuming there's a visa available, and we may go into that discussion later. But, just the wage determination could take several months, 6 months. Once that's done, then, of course, the employer has to advertise for at least 2 weekends in a paper or of general circulation in the area to show to the Department of Labor that they are legitimately trying to fill that spot, that employee spot, with a U.S. worker. They may be audited. They have to keep records of who replies to these advertisements to demonstrate to the Department of Labor if they cannot find a U.S. qualified worker who did respond to the advert at all, and why they weren't chosen. And if they pass that audit, or if they get past that stage, then ultimately they'll be applying for what's called labor certification. And that must be approved before the foreign worker can be petitioned by the employer on what is called an I-140, the employer petition, which is a critical prerequisite it's a prerequisite in order to either go to consular processing, where the foreign consulate will make the final determination of whether that individual will be given the EB-3 visa and then ultimately legal status, or the employee will try to adjust their status if they're present in the United States. So we go from wage determination, we go to labor certification, we go to the I-140 petition. If that's approved by USCIS, then either the foreign applicant will either seek to adjust their status inside the United States or through the U.S. consulate in their respective country. And if they're approved, they will then have legal permanent status under that category. So in a nutshell, that's what's available, assuming a visa is available for that particular country. And it could take 2 years or more, depending upon the delays.
That's right. Thank you, Doctor. Now, switching gears a little bit, we have a lot of clients. About 70% of our clients are here in the U.S. on adjustment of status, right? A lot of them are on Fs, a lot of them on Hs, different types of visas, and they're going to go work in EB3 unskilled. One question that's come up quite a bit for me is that what happens if they go to their visa interview at USCIS and ICE comes out and says, "Hey, hands up," like what are they supposed to do in that situation? Like, how are they supposed to respond in that situation? Like, if they have an encounter with ICE at a USCIS interview or in general?
Well, in general, this is unprecedented. Having ICE officers being triggered by a USCIS officer to come downstairs and to detain a foreign applicant is, in my 23 years, virtually unheard of. It's not impossible. It has happened in the past, but not to the extent that it's happening today. So what can you do? If you have been targeted for ICE to detain you at your USCIS interview, if possible, ask the ICE officer for a copy of the warrant, which gives them, according to their perspective, the right to detain you. That warrant is key because more often than not, they're going to detain you under what's called INA 236. That'll be cited on the notice to appear. That's the charging document. But even before the notice to appear, they should have a warrant which explains under what statute or regulation you are being detained. You have a right to know that. And the sooner you grab that document, the better. If it says 236, that's good news because that mirrors a federal statute called 1226, which gives you the right to request a bond hearing in front of an immigration judge. We'll go into that later. Also, at the initial period, obviously they know who you are. They've got your file. They know your name. You want to speak to your lawyer and you want to exercise your right to remain silent because if you are being detained, you have the right to be silent. And bear this in mind. You're being detained under civil issues, not criminal. You're not a criminal. These are civil, alleged civil violations. So you have the right to remain silent, keep calm. If you have a lawyer, the lawyer will try to get a copy of the warrant, and then the lawyer will go to work and try to get you released before an immigration judge with a bond hearing. That's all I can tell you. There's very little you can do at that moment other than to remain silent and ask for a warrant. And if you don't have a lawyer, you want to speak to your lawyer as soon as possible. I'll stop there, Chris, because you may have other questions. So
yeah. Now, one thing that we've seen is traffic stops. A lot of people will be in the middle of a traffic stop. And the police will pull them over, and then suddenly, like, an ICE agent appears and is like, "Hey, I'm." The police might call ICE, especially in places like Georgia, where that happens quite a bit. What can whether you're a U.S. citizen, one of our prospective clients, or even if you're here undocumented, what can you do if you're at a traffic stop and you get pulled over? What are your rights in that scenario?
If you're going to be pulled over by ICE, I can tell you it's going to be 3 to 4 SUV vehicles, not one. They're probably going to block you. 2, you should have, if possible, a valid driver's license with you. You will ask whoever is asking you to pull down your window while you're being pulled over. If they say they are arresting you because they're ICE, at that point, you should only give them your name and nothing else. Nothing else. Not what country you're from, not what your status is. They will bait you to have a conversation. Anything you say will be used against you. So You will exercise your right to remain silent, and you want to speak to your lawyer as soon as possible. Don't resist. Don't cause a commotion. It's not going to do you any good. Just cooperate. Of course, you can ask for them to present you with a copy of any warrant that they seek to detain you with. Always ask for that warrant. Unfortunately, these officers are not presenting themselves with ID. It's a dangerous situation. They're covering their faces. They're not showing their ID. And it's dangerous because we don't know what other nefarious actors are pretending to be ICE officials. But more often than not, they're going to be ICE. And again, just aim if they're going to detain you. Will they break your window? They will. They've been doing it. And so if you resist, just be prepared for that. More often than not, however, you want to prepare before that happens at home. You want to copy any papers that give you legal status in the United States. You want a copy of any marriage certificate, birth certificate of any of your children or other family members. If you've been paying taxes, you want copies of your taxes. You want photographs of your family, because all of these documents will ultimately be used somewhere to get you released from detention in a bond hearing. So gather those documents now. Don't wait until you're being detained. That's like an insurance policy. Make sure your spouse or someone else that you have trust has copies of these documents, because later on, most likely an attorney will need these to advocate so you can be released. But at the moment of detention, just give them your name, nothing else.
Okay. And what are you, do you have to, if they ask you, you know, show me your paper, show me your documents, do you have to show them the documents right then and there, or, you know, do you have to give them your identity documents, or can you wait until your attorney comes in and gets you or is nearby?
Well, one approach is to show them nothing. I mean, if you have legal status here, employment authorization, a valid driver's license, you can certainly try to show them that and see if they'll leave you alone. Obviously, if you're a U.S. citizen, you definitely want to make that clear. I mean, it's very unlikely that U.S. citizens are walking around with U.S. passports. However, that's starting to change. But if you have evidence that you are legally allowed to be in the United States, legally allowed to work, you have a valid driver's license, you can say, sir, I have legal status in this country. I'm authorized to drive. What's the reason that you're detaining me? Let them explain to you why they're detaining you. And if they start doing that, let me see a copy of your warrant. If they don't give you a copy of the warrant, then stop cooperating. Don't give them any more information.
That makes sense. And then let's say that, you know, ICE comes, knocks at your door at your house, and they say, you know, let me in. I'm ICE. Can you talk a little bit about what are your rights at that moment of the knock? Or what rights do you lose by letting them into your home?
The first knee-jerk answer is do not let them in. Start from that position. Do not let anyone into your home. 2, if that is ICE knocking on your door, you will tell them, give me, send me, or slip under the door a copy of your warrant. Is it judicially signed? It must be signed by a federal judge, not an ICE officer. They must show you that any warrant to arrest you must be signed by a judge. If they don't have that warrant to present to you, either at the window or under the door, do not let them in. If they still come in, tell them you object to the unauthorized entry into your home, and then from that point forward, speak silence. Do not give them any information. If you let them in, you've just given up your constitutional right under the 4th Amendment. They are now into your premises, and they can search anything they want. They may be able to arrest other people. And also, going back to the search warrant, it must be specific that they're looking for someone in particular at a specific address. It can't be a general warrant that says, we're looking for anybody here. There must be somebody named in the warrant at a specific address that gives them a judicial right to come into your home. If they don't have that document, they are not by law allowed to come into your home.
Thank
you. I hope that helps.
And no, that's very, very helpful. I think it's important that people understand, you know, what are their the rights? That's, those are the types of questions that we get a lot of here with BDV and our clients. And I just think that I know that they need to know what those rights are, what their obligations are, and what they should do in that circumstance. Now, if ICE goes and visits your job, right? Let's say that you have an EAD, valid EAD, and they come to your job site or your work site, and they start asking questions of the people at the work site. What is like the best practices for something like that?
The best practices, Chris, start with the employer, because the business location is a private sphere. It is not a public forum. It's not like ICE is knocking on the door in a public forum.
Mm-hmm.
Entering a business premise requires a warrant, just like with the home. So you should be having a conversation with your manager or the employer that controls that space. They should have a company policy that says that no one is allowed to enter the business environment without a search warrant, similar to the warrant I was referring to before. It must be a judicially signed warrant targeting a specific person at a specific address. So if ICE appears inside the employment sphere, the employment premises, without a warrant, first of all, your employer just made a big mistake letting someone in. And at that point, you are at the mercy of ICE because the employer has given them permission to enter the premises. At that point, just give them your name and remain silent. And if they're allowing you to leave, you can ask them, am I allowed to leave? If the answer is no, then you are arrested. You're under what's called a custodial interrogation. You just give them your name, and I want to speak to my lawyer as soon as possible. But the real egregious mistake there is the employer letting them in without a warrant. As long as the employer understands that ICE needs a warrant to enter the business premise, you'll be protected.
Perfect.
So that's what I would say, Chris.
No, I think that's correct. And then, my last question on this topic, and then we'll switch over to others. But what if your loved one is the one who's pulled over or arrested by ICE, and you get a call from them saying, "Hey, I'm being held by ICE." What should you do as the loved one getting that phone call? What do you do or say?
Find out where they are as best as you can from that loved one. Are they still in the area? Have they been transported somewhere else? It's really important to identify where your loved one is, because a lawyer who will run to federal court will need to show where the loved one is in order to file what's called a habeas corpus petition. Two, ask the loved one if they gave her any papers to read. And most importantly, tell your loved one not to sign any document. More often than not, if she or he signs a document, that means that they will be removed from the United States. That's a paper that's called self-deportation. They're basically saying, deport me. And many ICE officers are pressuring people who are detained to do just that. Of course, what I mentioned earlier, preparing all those documents ahead of time is going to help your loved one in this situation, so someone can react immediately to either request a bond with a judge or with the federal district court. Right now, most likely it's going to be federal district court. And the reason why it's important to know where your loved one is so the federal judge can create a wall to prevent ICE from removing that loved one from the area. Unfortunately, many officials with the Department of Homeland Security are disregarding even judicial orders not to remove people. They're still removing them. So backtrack again. That phone call, identify where your loved one is located as best as you can. Two, how is she being treated? And ask the loved one if they have any other documents that you could use at home. And three, do you have the telephone number for a lawyer that you can call? Don't wait until your loved one is arrested to try to find a lawyer to help you. Get those people in place now. So that's what I would recommend, Chris.
That's perfect. And, I think that, for our business and what we do, we really do help clients, prospective clients and those who sign up for our program navigate this immigration process. And now more than ever, competent attorneys, competent experts in this field are needed. there's just so many different moving parts to immigration. There's so many different changes. You need people who are going to, represent and help your clients and really understand what's at stake with a lot of these things that are going on. And so that's what our company does. And we work with individuals like yourself and others really to help navigate all of these issues that are going on in immigration, to make sure that our people who sign up with us are aware of the good and the bad. I often compare immigration to a ship, and we're all just trying to get from port to port, stormy seas and sunny skies, irrespective of what we face. And so, really glad to talk to you today. And I'm gonna, there's a few questions, and I'm gonna go ahead and answer some of those questions, and you can, jump into. Someone's asking if a F1 student applies for EB3 this year, how long or which year is it predicted that they get their green card? Like Dr. Pappas says, like it's just really hard to know. Right now with EB3 unskilled, you should expect a 3 to 4 year wait when you're getting to the Department of Labor process, the USCIS process, and then you have to have your number to be valid, due to retrogression, and then you'll do the interview at the I-45 stage in the country or abroad. And so those things change though, right? Like retrogression gets better, it gets worse. But right now though, it's looking like 3 to 4 years. Another question on here is, what happens to the immigration cases from Afghanistan for EB3 and the other countries that are on the ban list? Right now, all of those cases are paused. It used to be that they would at least process the cases up until the interview, and now those things are paused. There will be lawsuits about those. Obviously, there are already lawsuits about that going on right now. But as of today, everything that has to do with those cases are paused. And even if you're about to get your U.S. citizenship, those cases are paused. But the last time we had such a pause, or the last time rather Afghans were blocked, you had a new administration, and then those things go away, right? And so that's kind of the only thing that you can really wait on is that change, barring that the lawsuits don't win, right? Because it's very possible that the lawsuits over this issue might win. It's one thing to block someone from getting the actual benefit. It's completely another to block them from the entire process. What do you think about that, Doctor?
It's a very unfortunate process. It happened after the shootings in Washington about 10, 12 days ago. 19 countries right now are being paused for any immigration benefits, from asylum to citizenship to green cards. All of those citizens are in a unfortunate limbo right now here in the United States. Some of them were appearing for their oath ceremony in Boston to become citizens, and they plucked out certain people from those countries, and unfortunately they were not allowed to complete their citizenship process. The key right now is to hunker down, stay safe, obey the laws, go to work, pay your taxes, just do everything right until the situation reaches what we call litigation. American Immigration Lawyers Association is lobbying hard in Congress to stop this. U.S. citizens are being asked to protest against these unfortunate pauses, for lack of a better term. It's an unprecedented time. The staggering degree to which these pauses are occurring have not occurred in my lifetime. So hunker down and just get on with your daily life, do your work, pay your taxes, obey the laws, and hopefully that will keep you out of harm's way until clarity returns with respect to which countries can resume applying for specific immigration benefits.
That's right.
That's
Now,
all.
there's a question. There's a question from a Brandon here, and it's a question for you. Not everybody has a lawyer. It says, wouldn't it be easier if you just show proof of your legal status instead of remaining silent and being potentially arrested? What do you think of that?
Well, the reality is, and I'll be blunt, they don't care about your legal status. It's not going to stop you from being arrested unless you're a U.S. citizen. That will get you released. Even they get detained for a day or two or three. But if they're detaining you, they've already targeted you. They've already done the research. They know what your status is. They're targeting you for another reason. And I don't want to go into the political realm, but I'm more inclined to tell you to just keep your information quiet. You have a right to silence. It's a constitutional right. And if you do the preparation that I talked about, and if you have a lawyer or somebody else that can ask for a bond, you're going to have a lot more success in the long run getting out. To resist at that point is going to be, for the most part, not productive, because ICE has already, they're going to detain you whether you have status or not. That's the unfortunate reality from what I'm seeing.
You know, one question that we often get, whether it's a BDV or my law firm or any law firm as immigration lawyers, is that you'll go to an ICE, like even a USCIS interview, and the USCIS officer or even the consular officer overseas is really tough, right? They're really hard. They're like, everything that you're doing is wrong. Everything you're doing is illegal. Everything is bad that you do. Admit to me that you're, a criminal. And one thing I often tell clients is that, and I was, as a visa officer, and I'm a former visa officer, we were trained to rattle people. We were trained to break people. We were trained to tell people, hey, everything you're doing is illegal, right? Just admit it to me, right? And so, I often tell people that if you're interviewing with USCIS and they're telling you, oh, everything you've done is fraudulent, everything you've done is bad, everything you've done is illegal, sign this paper. I tell people to take a step back, breathe, and realize that as officers, we're trained to try to get you to give up your status and give up your rights and leave the interview thinking that you're defeated or even withdrawing, right? Because we get a gold star if we get people to not continue the process. From your experience, Doctor, have you seen situations where USCIS, not even ICE, but USCIS has told people things that may not necessarily be the case or true?
I have not seen personally USCIS officers tell a client that what they're saying is not necessarily true, although they will say, can you explain an inconsistency? You said X in your documents, and now you're telling us Y. I need you to explain that. That's a little different. And there are going to be mistakes and inconsistencies during the interview or in the application. And I want people to realize mistakes are not fatal. They happen. They also should know that you're in an environment where you're nervous. That's not a form of intimidation. That's just a form of giving you, the applicant, an opportunity to explain why you said X on your application and why you don't remember it or why you're giving us new information. And if you have a plausible explanation, it should be fine. However, if you have too many of these inconsistencies, your credibility starts to go down. So be familiar with what you submitted in your application. Review your answers, because I'll tell you what, is that you're answering in your adjustment of status application, they're going to be repeated verbatim to you by the officer. There's no mystery here. They're going to ask you the same questions. And if you give different answers, red flags start going up. So do your homework. Make sure you understand what you wrote in your application. Don't say, oh, my attorney said that. Oh, my friend put that in. I'm not familiar with that. That you cannot rely on blaming someone else for any information that you don't have knowledge of. However, I have seen one USCIS officer try to intimidate one of my clients when we had what's called a second interview. In New York, it's called a Stokes interview. This is when the husband and wife are being interviewed, and the husband gives out one answer, and then the wife comes in from a different room and she gives out another answer, and it looks really bad. And now the officer is saying, sir, why don't you just admit you're lying? And at that point, I put my hand up and say, stop, and tell the officer, you have answers, you'll make a determination, but don't accuse my client of lying. You have to make sure that when you go into these interviews, that you are going to speak based on truth. If someone asks or tells you or insinuates that you're lying, you say, stop, I'm not lying. These are the facts as I know them, and I respectfully will rely on that information, sir. But to say that I'm lying is absolutely unacceptable to me. So stand your ground. Of course, if you have a lawyer, they're going to try to do that on your behalf.
Yes, that's their job. That's right. That's right. Absolutely. Someone had asked about if you apply for BDV Solutions, how do you get started with the application? If you have questions about the application, a member of our team will reach out to you on Facebook and talk a little bit about it. But in terms of this question about the labor certification being the initial stage, yes, the labor certification is the initial stage that you start with. The next question is someone who had their green card was approved in July 2022, but the case was reopened due to retrogression. This is I'd like to hear your opinion on this. We've seen a couple of these where USCIS basically accidentally gives a green card to somebody. Like they accidentally say, oops, like just kidding, like you got retrogression, we're so sorry. Most of the time, USCIS has called and been like, this is an accident, our bad, please wait. Or some people are like, no, I want my green card and I'm willing to go to court for it. From your perspective, what do you think would be the best thing to do in that scenario?
Well, that best thing is now time sensitive. We're in a different environment. What you described was pretty much an administrative error. Yeah. And more often than not, USCIS would say, look, we made a mistake and we have the right to revoke or rescind the green card. If it's a legitimate mistake, they gave the wrong, priority date, and technically you were given a green card in violation of the regulation, they can pull it. Good luck trying to fight that battle in court. So I think fighting that in court is going to be futile. If you believe, however, that their excuse for revoking or rescinding your green card is not accurate, you can certainly appeal that. If they're revoking it, they should be able to give you 30 days on Form 290B to either file a motion to reopen or to reconsider. You file a motion within 30 days to reconsider, you're alleging that the USCIS officer made a mistake in terms of interpreting the law, or if new evidence has now emerged that says they made a mistake, obviously you didn't have access to this information, it's brand new, and if you think that information is not valid, you can file a motion to reopen and say, look, I didn't have this information. The information on its face is not justified to revoke my green card, and I object. And if you are denied that green card, unfortunately, even with the motion to reopen, there's no appeal process after that stage. You can't do anything except reapply all over again. You can't go to a court office. So if they ultimately deny you on an adjustment of status, a green card, there's no appeal except the motion to reopen or a motion to reconsider. However, I'm talking about a different time period when those kinds of things were not common, and most often than not, they were resolved. Today, however, especially in the last 10 days, thousands upon thousands of green card holders are going to be what's called revetted. They're going to be revisited. ICE today, not ICE, USCIS today is implanting or developing and putting in place fraud investigation units. There's always been fraud investigations with USCIS, but they are hiring, I don't know how many, hundreds or thousands. New centers are being put up in Atlanta and other places solely for the purposes of revisiting prior or previously approved green cards. And if they believe mistakes were made, they are going to seek to reopen them. So that's a whole new chapter in terms of its scale. So that's my response to that, Chris.
Thank you, Doctor. Well, we're right at time. Thank you so much. Thank you, everyone, for your questions. Again, this goes back to why immigration, especially now, is not something for the faint of heart. And you really have to work with people who have an understanding and a knowledge and experience that have been through Trump 1, Trump 2, whatever has been, come our way. And so thank you so much, Doctor, for being with us today. Hope to have you back again. Thanks, everybody.
Thank you. Thank you.
Thank you.